Good evening and welcome to everyone to the September 18th, 2023 special hearing for the KRE Curative Amendment. I'd like to welcome everybody who's here. I'm going to ask our solicitor to kind of take it from here. Maybe you could lay out some ground rules and tell us how we'll proceed this evening.
Certainly, Mr. Chairman. This is the second hearing on the application of KRE Upper Macungie for a curative amendment to the Newtown Area Joint Municipal Zoning Ordinance regarding apartment uses. Ground rules for tonight, we are going to open with a decision on the various motions that were made at the last hearing for which argument was submitted. We will decide those motions and then we will proceed with the hearing. The applicant has a witness prepared and ready to go this evening. So the board will be the fact finders. The board will sit back and listen as a judge would do in a courtroom to the evidence presented. Mr. Murphy, who represents the applicant, will be asking Mr. Comita questions on direct examination. Once he has completed that, Mr. Bagley, on behalf of the ordinance defense, will be asking him, Mr. Comita, questions on cross-examination. Once we're done with principal counsel in that matter, we will turn it over to the board for questions. We will then find out if there are any more witnesses this evening for the applicant, and if not, we will probably continue this to a date, continue the hearing to a date certain in October. So that's the procedure. Any of the board members have any questions on the procedure for this evening?
I do have one more admonition, that when you're speaking, that you please turn your microphones on. That's from the AV.
Yeah, I think our
panel upstairs.
Control pod upstairs has said make sure you turn your microphones on. There should be a switch on there, standard turning microphones on. Okay. Thank you.
Mr. Solicitor, I have a question.
Certainly.
Is there any public comment allowed tonight?
No, there will be no public comment allowed tonight. Public comment will come at the end of all of the evidence that is presented to the board. Once all of the parties have presented their evidence and all of their witnesses, before the hearing ends, we will open it up for public comment. I don't see that happening this evening, so folks are certainly willing to observe and listen, but I don't think we're going to have any public comment this evening. Thank you. Mr.
Advise Mr. Bagley this afternoon. Mr. Comita would be our only witness to be presented this evening. This evening?
Right. Okay. Okay. So we will proceed with that. So as I noted, preliminarily we had 3 motions made at the last hearing. Before I decide them, I will note that Mr. Mack, Supervisor Mack, has obtained counsel to represent him with regard to the motion to disqualify him and consideration of recusing himself from this hearing. Mr. Bryce McGuigan is here from Begley, Carlin, Mandio, representing Mr. Mack, so I will note that his representation for the record. With regard to the motions, we have a motion to strike paragraphs 8 and 9 of the application made by counsel for the defense of the ordinance. That motion is denied. We have a second motion to exclude what counsel for the township has qualified as irrelevant evidence regarding Mr. Mack's alleged predisposition in this matter. That motion will also be denied. And there was a motion by the applicant to disqualify Mr. Mack from hearing the case. That likewise will be denied. But in that vein, I must ask Mr. Mack at this time whether he can hear and decide this case fairly based on the evidence presented to the Board of Supervisors in this proceeding. Mr. Mack?
Yes, I certainly can do that. And I would just like to add a comment, if I might.
Certainly.
I would like to make clear that I have no direct or indirect interest in the pending application of KRE McGuiggy Associates LP. I have not predetermined the application and hold no bias against the applicant or the pending application that is before the board. I will consider this application as I consider each and every application that comes before the Board of Supervisors. I will review and listen to the evidence as presented by all parties, openly and fairly consider this evidence, and ultimately render a vote on the application based only upon the evidence of record presented in an open hearing before the board. I look forward to faithfully carrying out these duties delegated to me by the residents of Newtown Township when they elected me to this office that I am so privileged to hold. Thank you very much.
Thank you, Mr. Mack. And now we turn to Mr. Murphy to call your first witness.
Thank you. Good evening. My first witness would be Tom Comita. I'll have Mr. Comita sworn. Mr. Comita, for the record, would you give your full name and business address, please?
Yes, my name is Thomas J. Comita.
I'm looking up at, off the record, I'm looking up at our booth and seeing if Jeff can give us some, now he says try it? Now he says try it. Okay, maybe that one. You want to try that orange one, say, or red, whatever that color is?
There's always the podium as well as an option.
My name is Thomas J. Comita, C-O-M-I-T-T-A. And business address,
It's on off.
It's on and off again.
Yeah, it's off again. So, Tom, if you would just keep your voice up until we see if there's a solution.
sure. So my name is Thomas J. Comita, C-O-M-I-T-T-A. My business address is 18 West Chestnut Street, Westchester, Pennsylvania.
And what is it that you do for a living, Mr. Comita?
I'm a town planner and landscape architect.
And for how long have you been involved in that business?
As of July 16 of this year, 50 years.
And are you self-employed or employed by someone else?
I'm president of Thomas Comita Associates Incorporated.
And where is that located?
Again, 18 West Chestnut Street, Westchester, Pennsylvania.
And as the principal of that organization, what's the scope of your duties and responsibilities?
Well, we're primarily municipal planning consultants, and currently our firm represents 26 municipalities in Pennsylvania. In that capacity, we prepare ordinances, comprehensive plans, review plans, serve as an expert witness. Because we're landscape architects, we also design parks.
What's your educational background?
I have a BSLA, Bachelor of Science in Landscape Architecture from Penn State University, and a Master of Landscape Architecture from Harvard University.
And what professional organizations or associations or registrations do you maintain?
Primarily three. The most relevant to these proceedings would be AICP,
Which stands for what?
American Institute of Certified Planners, and I've been a certified planner since 1977. I'm also an accredited member of a group called CNU, Congress for the New Urbanism, since 2002, and I'm a registered landscape architect in Pennsylvania since 1991.
I'm going to distribute a copy of Mr. Comita's CV to the board members and to Mr.
Thanks.
Bagley. And Dave, I'm going to ask you if you could remind me what the exhibit number would be.
I believe this is the first applicant's exhibit. I don't believe we marked, let me double check.
Thank you.
Yeah, this will be Exhibit A1.
Tom, we've marked as Exhibit A1 your CB. You mentioned that as part of your employment and ownership of your company, that you represent multiple municipalities in terms of providing planning services and the like. Without getting into great detail, just give the board members in the audience a representative sample of the entities, both private and public, that you represent.
Sure. Exhibit A1 is a 3-page exhibit. The third page has a series of bullet points that identify the scope of professional services of Thomas Commit Associates. The second page is called By the Numbers.
And let's talk about those. You've highlighted in 11 or 12 bullet points a summary of your 50 years of experience in the planning area. Highlight those if you would, please. You've already talked about the first one, your level and length of experience. Talk about the other bullet points if you would.
Yes, earlier I mentioned that Thomas Commit Associates currently represents 26 municipalities. Item 2 on the second page of A1 indicates that since 1981, I've worked for 133 townships, boroughs, and cities, during which time prepared over 65 zoning ordinances, over 30 subdivision and land development ordinances, over 50 comprehensive plans, and I've testified, and I go back to my beginning of my career, 1973, over 1,260 public hearings at which I was qualified as an expert witness. Because I have 3 certifications, I'm required to take a number of continuing education credits, and I average 35 hours per year for AICP, CNU, RLA. I also prepare zoning codes, and 8 and 9 talk about those initiatives. As a landscape architect, I also prepare plans. Number 10 talks about the preparation of over 1,000 different campus master plans, site plans, concept plans, land development plans, and the like. One of the regular tasks of TCA, Thomas Commit Associates, is plan reviews. I've done over 5,500 land development plan reviews since 1973. And then, as I mentioned, park plans, over 200. Municipal park plans, county park plans, playground plans, landscape plans.
I would offer Mr. Commit, as an expert in municipal planning, would offer Mr. Bagley the opportunity to cross-examine if he would.
Certainly, expert in municipal planning.
Yes.
Mr. Bagley?
Mr. Committa, how many times have you testified in a curative amendment or validity challenge case?
Probably about 40.
And what would be the most recent one, besides this one?
Most recent. I think most recent would be Lower Paxton Township, Dauphin County, earlier this year.
Okay. I don't have any other questions.
Is there any objection?
I don't have any objection.
Mr. Committa will be admitted as an expert in municipal planning.
Thank you. As we start the substantive portion of Mr. Committa's testimony, I'm going to mark as Exhibit A2 a document that Mr. Committa will describe and explain the relevance of it as I hand it out.
Exhibit A2 is a...
Wait, hold on, Tom. Let's get it handed out first, and we'll... We will mark this aerial photograph as Exhibit A2.
Mr. Committa, describe for the benefit of the board and the audience what Exhibit A2 represents.
Yes. Exhibit A2 is a aerial photograph. It orients north-south, so it's portrait format. It's 11 by 17 inches. It's titled KRE Site and OR District, and it is dated 4/3/2023. It depicts,
You prepared this document.
yes, yes.
And describe the different colored outline of a particular area in the center of that exhibit. Describe what the relevance of those lines are, if you would.
Sure. The yellow line, which envelops the other lines, is actually a part of the boundary of Newtown Township in the southeast corner. The orange line, as indicated in the legend in the bottom right corner of A2, is the boundary of the OR district, and the red line is the KRE site outlined in red. The KRE site being approximately 18 acres. It's 17.869 acres, and it adjoins on the west side the bypass.
And looking at Exhibit A2, looking to the right of the yellow line and to the bottom of the exhibit below the yellow line, you're indicating that that is the limit of the municipal boundary of Newtown Township. So is
Correct.
it to the right, if you will, looking at the exhibit, that is an area located in Lower Makefield Township?
Correct.
And to the south, what municipality would that be? Middletown?
Middletown, yes.
Okay. You indicated that the property itself is slightly less than 18 acres, and it's currently zoned OR. Is that correct?
Correct.
And what does OR stand for?
OR is, we'll go right to it. Bear with me 1 second. I'm going to get the zoning map so make sure I got the right designation. So, according to the joint municipal zoning map, the OR district is office research.
Correct. Okay. And you make reference to the jointure ordinance, or the joint municipal zoning ordinance, or the joint municipal zoning map. Describe for the benefit of the board and the audience why and what is a jointure as it relates to this particular zoning map and the location of the KRE site within the OR district.
Sure. So Newtown Township is the southernmost of the 3 municipalities of the jointure.
What are the 3 municipalities that make up the jointure?
Yeah, Upper Makefield is north and east of Newtown, and then Wrightstown Township is to the west of Newtown Township.
You are aware, are you not, that in 1984, multiple municipalities created the jointure and adopted a zoning ordinance. Is that not correct?
Correct.
Okay. And at the time of the creation of the jointure in 1984, there was an additional municipality that was part of that initial jointure effort, right? Being Newtown Borough.
Newtown Borough, yes.
Right. And subsequently, Newtown Borough elected not to continue to participate in the jointure, and as today you've indicated, it's 3 municipalities that make up the jointure, right?
Correct. The zoning map that one accesses online actually has the color white because Newtown Borough is excluded, from that jointure.
Right. Let's go back and talk about the provisions made originally in the 1984 jointure ordinance for different types, if you will, of apartments. And we're talking about uses B11 and B10, right?
Yes.
Okay. And the board and the audience are aware that we, KRE, the thrust of our application is to reintroduce, if you will, a B11 type mid-rise apartment use to the jointure, right?
Yes, and
Why is that necessary in your view?
several reasons. First, let me say that from 1984 to 2005, the use that we're requesting, B11 mid-rise apartment use, was in the joint municipal zoning ordinance. And for the record, the section of the jointure ordinance between 1984 and 2005 is section 803, point capital B, point capital B. So B11 was the use that was allowed, and at the time, that ordinance said B11 mid-rise apartments and gave a definition by saying it's an apartment building in a detached building with no less than 16 attached units.
No less than.
No less than.
And what about the number of stories that the B11 use would have allowed?
3 to 6 stories. It also promulgated the maximum length of a building to be 125 feet, or, one side of a building. And then it also promulgated that there would be 3 parking spaces per dwelling unit and related buffering standards.
At the time of its inclusion in the jointure ordinance beginning in 1984 and continuing until 2005,
Correct.
was the B11 use that you've described and which is outlined verbatim in our application, was that ever a standalone use in the ordinance? And first, before you answer, explain what we mean by a standalone use.
So, a standalone use would be a building that, in this case, an apartment building that by itself has 4 sides usually. Maybe there's more sides if it's longer, or it wiggles in some way. And from basically ground to roof, it's all apartments. So in contrast to, let's say, a mixed-use building that would have ground floor non-residential with apartments on second, third, whatever floors.
In the original jointure ordinance, again, from 1984 through 2005, would you agree that the B11 mid-rise apartment use that you've described and which we've outlined in our application was only allowed in an R2 medium density district and only then as part of a performance subdivision?
Correct.
Okay, so through the first number of years, from 84 through 2005, a mid-rise apartment use could not be built unless it was part of a performance subdivision and then only in a certain singular zoning district, right?
Yes.
Okay. What about the B10 use?
B10 is garden apartment, and that existed from 84 to 2005, and still today it does.
Okay. And is that use, the B10 use, a standalone use, or does it have to be, much like the B11 use, does it have to be part of something else in order to create it?
Yes, it has to be part of a performance subdivision, and it's allowed currently in the CR2 district, the R1 and the R2 districts.
And as you've indicated, the B10 use could also be allowed in the TC district, right?
Yes, in a TC district, it's allowed in a mixed-use building whereby 40 to 50% of the building may be utilized for residential use. And when I toured the township a few months ago, I just noted the apartments above the anthropology store on Sycamore Street be an example of the mixed-use building with apartments in the TC Town Center District.
But unlike the original B11 use that had to have at least 3 stories and had to have no limit on no less than 16 apartments.
No less.
The B10 use had a limit on the number of allowable apartments, did it not? As part of that mixed-use opportunity.
Oh, yes.
And what is that limit?
Well, as I mentioned, it's 40 to 50% of the building.
And in the ordinance itself, it makes reference to a maximum of 16 units, does it not?
Right, and also 16 units, correct.
Okay. So, what happened after 2005 in the jointure ordinance as it relates to the B11 use?
It came out. I don't know. Perhaps we'll find out in these proceedings. I don't know.
But as our application indicated, in 2005, the jointure municipalities amended the jointure ordinance to remove the B11 use.
Correct.
Okay. And to the best of your knowledge, has that B11 use ceased to exist since 2005?
Yes. Ironically, when they cut out the use, they still left the parking regulations in. So if you look at the current ordinance, B11 has parking regulations, even though the use is not recited in the use section. Someone forgot to take out the parking in the for B11.
Okay. And again, our application highlights and attaches as an exhibit the actual adopted ordinance removing the B11 use from the joint municipal zoning ordinance, right?
Correct.
Okay. So as we sit here today, is there any opportunity in the current jointure ordinance for an applicant to construct a standalone apartment use of any size?
No.
Why is that?
Well, it has to be part of a mixed-use building in the TC Town Center District, or it has to be part of a performance subdivision in CR2, R1, or R2.
Okay, and there's no opportunity today, nor has there been since 2005, for an applicant to construct what was referred to back then as a mid-rise apartment project?
Correct.
Okay. Now, from a planning standpoint, let's talk about the various merits that you've identified as worthy of consideration as part of this curative amendment application.
Sure. Well, in terms of the KRE application, presumably they have done market studies and analyses to determine, the development program on what was Unit 3 of the former office campus. And I took a look at it just from a fresh set of eyes. First, from the county perspective, I looked at the 2010 and 2020 population and housing information. I then also looked at housing and population forecasts, but essentially in 2020, Bucks County had over 646,000 persons and over 256 housing units. So when you do the simple math on that, countywide, there's an average persons per dwelling unit of 2.52 persons per dwelling unit. And I had to make that determination because when I looked at the Delaware Valley Regional Planning Commission data on population forecasts, I had to then convert the population forecast into housing units to get a handle on, is Bucks County forecasted to grow or not grow? And then I looked at information on Newtown Township that came from the Delaware Valley Regional Planning Commission and asked myself the question, is Newtown Township forecasted to grow or not grow?
Mr. Sander, I'm going to make an objection.
Yes, Mr. Bagley.
The nature of the objection is this testimony about whether Newtown can grow or is about to grow is in the nature of someone who's making an argument in a curative amendment about a fair share argument. That is, saying that Newtown does not provide its fair share of, say, multi-dwelling housing. That's not made in this curative amendment. This curative amendment says this is a de jure exclusion case where mid-rise apartment buildings are not allowed, or it's a de facto exclusion case. You won't find the words fair share anywhere in the curative amendment challenge at all. So I would object to any testimony that's discussing whether Newtown is growing or not growing, because it's not relevant to the challenge.
Understand, Mr. Bagley. We don't quite, I don't think we quite know where it's going. It may be a fair share argument, and of course that is legal argument, so we will reserve that, and you certainly reserve your right to argue that. So we'll overrule the objection and allow the testimony to continue.
I'm going to mark as exhibits A3 and A4. Documents that I'll have Mr. Comita identify, each individually, and then we'll hear additional testimony. Let's talk about what we've marked as Exhibit A3, which I believe is an excerpt which you'll describe from the U.S. Census, highlighted as Quick Facts, Bucks County. Is that right?
Yes.
All right. Explain for the benefit of the board and the audience what Exhibit A3 represents.
Simply that it recites under population and the sixth line down, population census April 1, 2020, 646,538 persons. And then down under housing, in the first line down under housing units, 256,391. That is of July 1, 2021. So a few moments ago in my testimony, I mentioned those numbers. I just wanted to provide the board with an exhibit to show where I got them. That's all.
Okay. And Exhibit A4?
Exhibit A4 talks about the...
And identify the document
sure,
first,
sure.
the source of the document.
Sure. A4 are excerpts of a Delaware Valley Regional Planning Commission publication called Analytical Data Report, and it's called ADR for Analytical Data Report 022, July 2016, and it indicates county and municipal level population forecasts 2015 to 2045.
What's the relevance of this document?
Sure. Well, as I said before, I asked myself the question, is Newtown Township shown in any authoritative source as a place where growth is likely to occur, yes or no? And by looking at A4, I determined that the answer was yes. I did that on the basis of the following pages that are the excerpt of A4. After the cover page, the first page is page 4 of that document, called Forecasted Population by County 2015 to 2045, and I underline Bucks County, and it gives the forecasts for 2020, 2025 through 2045, and then on the far right columns, it talks about absolute and percent changes. And so the population forecast for the county is for 11.5% growth. However, the following page, which is Figure 1, Municipal Population Forecast, Newtown Township is shown in the medium color, medium being, there are 5 colors on the left top corner of that Figure 1, and they range from a beige to a brown, and the medium color is somewhat orange, but Newtown Township is in the range of 6,000 to 12,000 people on that exhibit. Realize that that goes to 2045. Then on the following page, Figure 2, the municipal population forecast, absolute change. Again, Newtown is in the medium color. Bear with me one second. Actually, it's in the slightly down. It's the 4th color down. With the absolute change being 1,501 to 5,000 people. And then the following page, Figure 3, the municipal population forecast. For Newtown Township, it's the medium color, moderate growth, plus 6 to 20, plus 25%. And then it's followed by 2 pages from Appendix A, the forecasted population by county and municipality. And on the next to the last page of Exhibit A4, I underline Newtown Township. So as you go through the vertical columns and look at the forecast from 2020 to 2045, you see the incremental growth that is shown in terms of forecasted population. And the far right side says percent change 2015 to 2045, 9.4%. I also just underscored Upper Makefield and Wrightstown Townships on the last page, but we're here talking about Newtown Township, so I'll just stop at that.
But, if you would, the relevance of the population forecast that you just reviewed with us suggests that if there is going to be an opportunity for Newtown Township to grow population-wise, where would the most logical place within that jointure, those 3 municipalities, be?
Objection. Same objection about the curative amendment challenge not being about a fair share argument. It is entirely about whether apartments are allowed in Newtown or not allowed in Newtown.
We'll overrule the objection.
Could you read back the question? I'm sorry.
Well, I'll do it.
Okay.
You've reviewed with all of us the population forecast from the DVRPC report.
Yes.
You have highlighted the forecast of growth in Newtown Township and, to a lesser extent, Wrightstown and Upper Makefield, all members of the jointure.
Correct.
The question for you is, why is the KRE site, given those forecasted numbers, a logical place for a project such as KRE is proposing to be located?
Oh, yes. Well, there's several reasons. First of all, the OR Office Research District already is a mixed-use type of district. There are many uses that are permitted. It has the Newtown bypass, Route 332, running through it. It has public water and sewer, and it adjoins zoning districts that are higher intensity use. So in the whole jointure, when you go east of Newtown Borough toward the OR district and the KRE site, it's the most intensively developed area of Newtown Township. In contrast, Upper Makefield, much more rural, Wrightstown, much more rural, lower population, lower amounts of housing, lower amounts of mixed use throughout.
And given those numbers in the forecasted information you shared from DVRPC, Newtown Township's existing population is more than double Upper Makefield and even more than that than Wrightstown, right?
Correct.
Okay. And which of the three jointure municipalities has the most diversity in development opportunities?
Newtown Township.
Why?
Well, from the standpoint of the zoning map, the joint municipal zoning map, most of Upper Makefield is shaded in the color green, which is either Jericho Mountain or conservation management. There are other colors that are on the eastern side, but the majority of the land is zoned for conservation management. Similarly, in Wrightstown Township, again, although there's a variety of CR1 and 2 uses and R1 and R2, a substantial amount is conservation management. In Newtown Township, in the areas that adjoin Wrightstown and Upper Makefield, they share that conservation management. However, when you get around Newtown Borough, and especially east of Newtown Borough, you pick up the first LI district, which is on the sort of the west side of the bypass. You pick up the only OR district in the entire jointure, and essentially there's more buildings, more streets, more roads, more sewer, more water.
So the utility infrastructure is obviously a critical element in the ability of more intense uses to be located within the jointure limits, correct?
Correct, yes.
And in Newtown Township in particular, that water and sewer infrastructure exists
Yes.
and would support the more intense developments that are existing today in Newtown Township, right?
Yes.
What about the impact of the bypass, the Newtown bypass?
Well, from the KRE site, you could be at Interstate 95 within 5 minutes, which is very close. At the KRE site, it's about 1 mile west of the apartments that are being completed in Lower Makefield at Prickett's Preserve. And given the current zoning in Newtown with the LI and the OR district, both of which are very logical that they're along the bypass, it's kind of a growth opportunity area. It's an area where a substantial amount of development has already occurred.
So why does the KRE site for the proposed market rate apartment project that we presented make sense?
Well, first of all, it was already approved as a 4-story office building as part of Unit 3. Unit 1 and 2 were built, and they're just adjoining the KRE site. And so...
And the history of that office development use is outlined in detail in our application, correct?
Yes. So Unit 3 was approved as a 4-story, 210,000 square foot office building with 1,050 parking spaces. And essentially, not exact footprint, but essentially the proposed KRE development could fit in the same area that's proposed for development, was proposed for development for the Unit 3 offices.
Has the township, Newtown Township, recognized, to your knowledge, the opportunity and/or need to identify additional areas to provide for market rate apartments?
Not yet.
And what do you mean by that?
Well, another document that I reviewed to prepare for my testimony was the 2009 comprehensive plan. And that's 14 years old, and it looked at growth between 2005 and 2015, but admittedly, because it was adopted in 2009, had the benefit of looking at what happened between 2000 and 2009. And there's a little bit of information in the comprehensive plan on a growth principle that says if you're going to have growth, it should be along a major highway. And that gave me some comfort because that's exactly what the KRE proposal is about. But the zoning that we're here to talk about in these proceedings is, from KRE perspective, limited to the B10 apartment as part of the performance subdivision and the town center mixed use, 40 to 50% of the building, and not a standalone B11 use that is being is the subject of the curative amendment.
I'm going to mark and introduce two additional exhibits that you've reviewed, and I will hand them out, and then I'll ask you to identify them.
Thank you.
I've introduced or marked as exhibits and circulated two documents, Exhibit A5 and Exhibit A6. Would you please describe, for the benefit of the board and the audience, what they represent?
Yes. A5 is a 7-page document that's dated top right corner 7/2023. Its title is Newtown Township Overlay District Regulations for the LI Light Industrial District and the OLI Office Light Industrial District. And incidentally, those two districts are just to the west of the KRE site, on the west side of the bypass, according to the jointure zoning map, and part of the commons. And so the words at the top, right below the bold title, is LI/OLI Newtown Commons Overlay District. And then A6 is a 2-page document that is also dated July 20, 2023, title on the top left is Proposed New Uses, and then it's kind of an outline of mixed-use development, and goes on to the second page to talk about mixed-use apartments. And in A5 on page 3 at the bottom, it talks about the density shall not exceed 20 units per acre of base site area.
It's your understanding that both these documents have been reported out of the Planning Commission and will be the subject of further discussion before the Board of Supervisors in the coming weeks, correct?
I'm sorry, what do you mean by reported out of the Planning Commission?
The Planning Commission has considered it and is now referring those documents or those proposed modifications of the ordinance to the Board of Supervisors.
Mr. Sander, I'm going to object to A5 and A6 because it's become clear from the testimony that they are proposed ordinances.
Yes.
They're not enacted.
I agree, they are
We
proposed
agree.
ordinance, they are draft ordinances. I think that's what they're being submitted for, and certainly the board can accord them the way it wishes to accord them, so we'll allow it to proceed.
Thank you.
Yes.
Okay. And what is the significance from a planning standpoint of these two documents in their current form?
Well, when I first saw them, I said eureka, meaning that, and it's my understanding, Mr. Murphy, from talking to you about it, is that they originated from the Bucks County Planning Commission. And so, to me, it represents being cognizant of the need for more zoning in Newtown Township for apartments, which ironically is right next to the OR district and adjoins the OR district.
But even with those, your observations of the significance of those, the additional uses being proposed, including what's referred to as town center apartments in section C1B of Exhibit A5, it also limits that use to only in a mixed-use development, correct?
Correct.
So it's still, even to this day, even with the thought of adding more apartment opportunities in the township, it still would not be a standalone use.
Correct.
Okay. With regard to other planning considerations which would suggest that the KRE site, subject to this application, would be the most appropriate place for additional market rate apartments. If you could highlight those additional considerations for us, please.
Sure. So, for those 130-plus municipalities that I've represented, the 26 that I currently represent, I have to perform analyses similar to what I did to prepare for this hearing, and I have to understand all land uses. I do understand them because I've reviewed 5,500 land development plans in my career. At this point, it might be over 6,000. But when I review a plan, I become familiar with the proposed use and the manifestations of the use, the density, the height, the size, the way it's positioned, the parking, circulation, pedestrian and vehicular, and also take a look at, especially when I'm doing an entire cover-to-cover zoning ordinance, all residential uses. And so in my 50-year career, it led me to ask the question, so why is a standalone B11 apartment use needed? A question that the supervisors might ask, a question that I might be asked by the board under cross-examination. Why here? Why KRE? Why Newtown? And so I guess one of the easy answers is, well, the Bucks County Planning Commission must have thought you needed something other than what you have, otherwise A5 and A6 would not even show up tonight. But that aside, realize I started my career in 1973. Before I did that, I was the town planning intern for the town of Cape Cod in Massachusetts for 2 years while I was in grad school. I'm basically a student of land use information. I'm a student of studying different land use types. And so in the 1970s and 80s, so over 40 to 50 years, I've seen a considerable amount of apartment development in southeast Pennsylvania and in the Delaware Valley. Attributes that I have seen during the 50 years is often they're 3 to 6 stories in height. Sometimes they're higher than 6 stories. Very rarely lower than 3 stories. And so I'm not surprised that the B11 use from 1984 to 2005 for the jointure said 3 to 6 stories. It was normative. It's a normative building height. That's the same number KRE recites in the curative amendment. I've also seen, especially in the last 10 to 15 years, the normative size of an apartment building based on the economies of scale of building them. Whether you're in Chester, Delaware, Bucks, Montgomery counties. And I usually see them in the 150 to 250 dwelling unit range. Sometimes in a boutique borough setting, it might be less than 150. But in a suburban township setting, often in the range of 150 to 250 dwelling units. I've often seen a variety of bedrooms, some studio, some 1, 2, 3 bedroom, and that's to diversify the portfolio for the development type and to provide opportunities for persons of different abilities to afford the apartments. Overall, whenever I've written the ordinances to allow apartments, I've been mindful of the compactness of the layout, whereby, and in the early part of my career, I often did the apartments in a PRD district, and in several of the municipalities that I still represent, in fact, the apartments were built in some type of cluster development or PRD planned residential development. And so, in terms of zooming out and looking at a land use pattern in a community that is likely to experience growth in population and housing, the good news of the apartments is that under one roof, there are dwelling units that, especially like for the jointure with so much conservation zoning in the CM Conservation Management District, it saves the farmland. I mean, when you look at all 3 municipalities, you look at the growth, and you have to decide, am I going to spread out development on the farmland, or am I going to try to compact it where there's sewer, water, good road access like the comp plan talks about? Then there's no better place to put it than in the OR district, the LI, the OLI.
And you made reference a little while ago to the fact that the Newtown Area Joint Comprehensive Plan has not been updated in the last 15 years.
Correct.
The effort being made with the impetus of the Bucks County Planning Commission and now Newtown Township to propose for consideration exhibits A5 and A6 in your view, represents a well-thought-out effort to address those population trends that you've highlighted in your earlier testimony and to address those types of needs given that population growth?
Objection, leading.
Well, we've certainly allowed a degree of leading. Obviously, the strict rules of evidence don't apply. Maybe try to ask more declarative questions, Mr. Murphy.
I'm done if you let him ask that.
We will let him answer that question.
Good.
Yes.
I forget the question, but I don't.
And there
Okay.
you go.
Okay. I don't have any other questions for Mr. Committa.
Thank you. Cross-examine.
Mr. Committa, before I get into my questions, this exhibit that you identified, A4, from the Delaware Valley Regional Planning Commission,
Yes.
it's dated 2016. Is that the most recent version of this data that you were able to obtain?
I believe so. When I researched the information earlier this year, I had access to that information, and so that's why I produced it.
Do you know if there's any more recent information that's provided by the Delaware Valley Regional Planning Commission?
There may be after I had first queried, but when I first queried it, this is what was available.
Were you involved in the preparation of the curative amendment petition?
Maybe 5 or 10% to review and comment on drafts that KRE had prepared.
Do you know the difference between a de jure exclusion case and a de facto exclusion case?
Over the years, I have had opportunities to analyze that, yes.
Is KRE claiming a de jure exclusion or a de facto exclusion in this case?
I think you said earlier both.
And can you explain that to us, that they're claiming both?
Objection. That is truly a legal conclusion that's being asked.
Can you repeat the question, Mr. Bagley?
If garden apartments are referred to, as you've said, they are, in the joint municipal zoning ordinance, how can the ordinance be de jure exclusionary?
Objection. That's a legal argument to be addressed.
It's certainly a legal argument. However, Mr. Committa has been qualified as a municipal planner. He's certainly testified that he's written many zoning ordinances. So keeping in mind, board members, that that is probably the ultimate legal question in this case. We will allow Mr. Committa to answer that question to the best of his opinion, professional opinion.
So if a municipality has a de facto exclusion, if that were the case in any municipality, it would likely be that the use in question is not recited in the ordinance, whereas the de jure, when you kind of navigate through the ordinance and you look at limitations on units or size, or like in the town center town center district, where it's in a mixed-use building, 40 to 50%. The specific B11 mid-rise apartment that's part of the KRE curative amendment would not have been submitted if that use was in the ordinance. So KRE is saying, we've looked at your ordinance. We believe that there is a logical cure for the omission of a freestanding apartment that's a B11 use in the way that the curative amendment outlines. And either the board will agree with that curative amendment or they won't agree with it, but that was the opinion that KRE had. When the use is allowed only in B10 as part of a performance subdivision in CR2 and R1 and R2, you have to navigate through, and once you determine that you could do apartments, it's very limited. So the reason I said just before Mr. Murphy said he had no more questions for me, that I talked about normative number of units, 150 to 250, and freestanding and so forth, is that you can't do that currently in Newtown Township. And I believe, although I did not write that, I assume Mr. Murphy did, for the de jure, it's that you have to whittle your way through and wind your way through the ordinance to find out that you can only do a limited number of apartments and not what I would consider, and I've said, as a normative freestanding B11 mid-rise apartment use.
Is Newtown Township obliged, as a municipal land planning expert, to provide for mid-rise apartment use?
Objection.
Overruled.
It's a great question, because when I first met you, Mr. Brinkley, you mentioned what you thought about Section 6045 of the Municipalities Planning Code, that makes it a responsibility for municipalities to provide for all basic forms of housing. It was your opinion, as you said the first hearing, that you already do. It's my opinion that you already don't. And so it's my opinion that one of the basic normative forms of multifamily housing, 50 years of experience, 133 municipalities, is that it is normative. That I believe if Newtown Township was not a growing community, did not have the sewer, water, road access, did not have the OR/LI zoning, did not have the intensive level of development, it might be a stretch, but it has all those attributes. And so when I started my career in 1973, and I said this when we appeared in this room, maybe it was with the Planning Commission, I said that my experience on behalf of municipalities with curative amendments is a property owner says, I have an idea. I think that this curative amendment will cure a defect. And it would start a dialogue that sometimes the municipalities accepted the curative amendment, sometimes they rejected it, sometimes they offered a counter proposal. And that's how my career started in looking at these curatives. You asked me in voir dire, that I have experience testifying on curative amendments and validity challenges. I'd say more curative amendments than validity challenges, all the while trying to fairly appraise what the request was and to determine what I believe to be normative. In this case, I believe the B11 standalone mid-rise use is normative.
What is a performance subdivision?
Good old Lane Kendig, 1973 to 1980, Bucks County Planning Commission wrote the treatise Performance Zoning. And the notion was you look at a property, you look at its attributes, you look at certain water, sewer, road attributes, you look at soil, slope, hydrology, woodland, floodplain attributes, and you would sort of calibrate the performance of the development type according to the attributes that are so identified in the ordinance.
how would you like to mark this, or would you like to mark it, Mr. Bagley?
O.
Oh, I think that's probably a very good idea. We'll mark this as Exhibit O for Ordinance 1.
1. Mr. Committa, this is a performance subdivision in Newtown Township, is that correct? That is, this is the B14 use, referred to as performance subdivision?
I have the whole document, but I'll accept your representation of the excerpts. There's no page numbers or whatever, but I see at the top left it says B14, so I'm assuming that it is.
And it sounded from your direct testimony that the fact that garden apartments must be in a performance subdivision, you find to be part of the exclusionary use that's alleged here.
It does severely limit the ability for KRE to develop the normative standalone B11 mid-rise apartment use, yes.
If you look down in number 3 on the first page of 01, it lists the number of dwellings in a development. Is that correct?
Oh, yes,
And for 1 to 60, the first line, the minimum required number of dwelling unit types is 1, correct?
correct.
So in having garden apartments, if you had 1 to 60 units in a performance subdivision, you could just have garden apartments, correct? Because the minimum percent of any dwelling unit type is 100. So you could have 1 to 60 garden apartments under a performance subdivision, couldn't you?
I'm going to object because I'm not sure the question is accurate because he's not asking whether a performance subdivision is allowed in all the zoning districts.
I think what I'm asking is,
Yeah, I don't think, I
Can
didn't
you
think
have-
that's what you were asking.
can you have 1 to 60 units in a performance dwelling, or sorry, a performance subdivision of garden apartments?
But for right now, and I'm not sure where we're going with this, I'm going to say hypothetically, yes.
Okay. And if you look under number 4, dwelling unit types per district, under garden apartment use B10, under R2, it's permitted. It's P for permitted, correct?
So you want me to look at sub 4, correct, dwelling unit mix?
So, yeah, dwelling unit types per district,
Okay,
and under dwelling unit type, garden apartment, use B10, you're permitted to have them in a performance subdivision in R2.
correct.
So would you agree with me that you can have 1 to 60 garden apartments in R2 without having any other type of dwelling unit?
I'm going to again say hypothetically, yes, because there are many other pages of the ordinance that might put a little asterisk on that, and just on the merits of what you're looking at on the top of the second page of 01, hypothetically, yes.
Okay, and therefore you could have a garden apartment that's a standalone use, couldn't you? It's 1 to 60 units, but it's a standalone use
Bear with me one
in a
second.
performance subdivision.
Bear with me one sec. It's my understanding that the performance subdivision requires a mix of types. And I suppose that in number 3, where you hypothetically pointed out minimum number of types of 1, and then on the other page that it's permitted, there are other provisions that require the mix of types. So I believe that if you look at each and every site at which there's been a performance subdivision, the reason that you're not going to find a garden apartment use B10, even though it's permitted and even though it says what it says, is because there's other requirements that have to be met with other unit types.
Well, is there a requirement that there has to be a minimum acreage?
Not according to these 2 pages that you gave me.
All right. Bulk requirements, you have to still meet the uniform bulk requirements. Remember, the note was sent around the same note, you got to meet the individual bulk requirements. If you did have that. Okay, thank you, Joe.
I'm going to mark as O2 a document that's labeled Section 405 R-2 High-Density Residential Districts. Mr. Committa, I highlighted something there in the front that says Performance Subdivision, and Performance Subdivision under R2 includes garden apartments. You see that? Use B10?
Yeah, I believe when you say highlight it, you put the box around letter E?
Yes.
Okay, so in the box on the first page of O2 around E, Performance Subdivision, it says use B14, which is the same number that appears at the top left of O1, with a mixture of the following dwelling unit types only: single family detached, use B1, village house, use B2, atrium house, use B4, twin house, use B5, townhouse, use B8, multiplex, use B9, and garden apartment, use B10.
Now that you've mentioned a multiplex, what's a multiplex?
I'll have to go to... I don't have the whole zoning ordinance in front of me, so I have to go to the definitions.
Would you agree with me that multiplex is a type of multifamily dwelling?
Not yet. I need to look at the definitions. Does anyone have a copy of the zoning ordinance I can look at? I'm sorry I didn't bring mine.
Well, I'll move on. You don't have to answer the question right now. We'll come back to it. But in pursuing the issue about the minimum acreage, if you turn to page 3 of Exhibit O2, there's a table. And if you look in the table, there's a column that says minimum gross site acres. And if you follow that column down, along the side, on the left-hand side, it says performance subdivision. And if you meet up minimum gross site acres and performance subdivision, the minimum number of gross site acres is 25 acres, correct?
My apologies, I don't see what you're talking about, so can you again tell me where I should be looking?
If you look on here, and you go minimum site gross acres and performance subdivision,
Okay.
it says 25 acres, right?
Yeah, so I'm not sure to Reporter Harris, but the question was, when you look at page 3, the column titled minimum gross site acres, read down vertically, and then across from performance subdivision, you read across horizontally, it's 25 acres, correct?
Okay, so for a performance subdivision, you need 25 acres, correct? At least.
According to
Minimum.
this, page 3, yes.
And is it your testimony that that is an additional reason why the ordinance is exclusionary in requiring a performance subdivision because you need 25 acres?
Well, that's one of the reasons, as I said early in my testimony, we have a little shy than 18 acres.
Correct. So the KRE site is about 17.8 acres, correct?
17.869 acres, correct.
And the minimum acreage of KRE's corrective amendment ordinance is what?
I need to, I don't have that. I
Would it
think-
refresh your memory if I told you it was 15 acres?
I'd rather not guess, and I'll take a look at it if someone has that exhibit. My apologies, I don't have it in front of me. I recall 15 acres, yes. I don't have it in front of me, but I do recall 15 acres.
So do you think the 25-acre, I'm sorry, do you think that 25-acre requirement is too high because the KRE site does not meet it?
I think it's just too high in general. You know, in scarcity of land, it's not uncommon that sites that are enjoying good sewer, water, road access, many of them are between 10 and 20 acres that are appropriate infill development sites.
Did you ever say anything to the contrary?
Pardon me?
Did you ever say anything or have an opinion to the contrary that what you just stated?
Well, I represent boroughs and townships. Some of the townships are more rural. So it depends. I also have represented cities, so it all depends on, you know, the municipality and the conditions.
Mr. Committee, do you remember testifying in a township called Lower Chichester
Lower Chichester.
in a case called Appeal of Redeemed Christian Church of God? I think it involved a church that wanted to go into an office park, and the township zoning officer took the position that things like conference center and assembly were not allowed in that office park. And you testified when they sought a variance, and your testimony was that,
Objection, there's, Joe, don't let him, I
Yeah,
don't think it's appropriate for Joe to summarize what Tom's testimony was or is.
Well, I agree. Let Mr. Comita look at the exhibit, and then Mr. Bagley can question him on it.
Yes, Mr. Begley highlighted on the bottom of page 5 of 14, the top is 6 of 14, where it says that I testified that the planned development districts of 25 acres or greater. And in fact, in that municipality, they have them zoned at that size. So,
and you testified that things like worship services and conference centers could be used in those type of districts, and that 25-acre minimums were adequate and satisfactory for that use for the applicant, correct?
right, and you have to go there and see, you know, where the lay of the land of that district and the size of the properties around it and so forth, but it speaks for itself. And my direct testimony did not talk about 25 and 15 acres. I talked about the apartment use. So I think all things considered, the big ticket item on this case is the use.
Does the municipality's planning code define or single out apartments as a requirement for zoning ordinance enactment?
Not those words. It says, and bear with me.
I can give you the words, and you can tell me whether you agree with me that these are the words.
If you'll bear with me 30 seconds, I will give you the words. So 604, zoning purposes of Article 6, 1, zoning and the Pennsylvania Municipalities Planning Code talks about a reasonable range of multifamily dwellings in various arrangements.
It does not say mid-rise apartment buildings, does it?
That would be correct.
Have you ever been involved in a challenge involving a mobile home park?
Several.
And would you agree with me that that same section you quoted is where the language comes from that says municipalities have to zone for mobile home parks?
Yeah, there's a choice. You could do it in the subdivision land development ordinance or in the zoning ordinance.
So confirming what you're saying, that 6044, that's exactly where the language comes from that says what a municipality is responsible to zone for, correct?
Say the last few words of the question. I didn't hear the last few words.
Your testimony about mobile home parks confirms exactly what you're saying, that 6044 provides the terms that the municipality's planning code says the municipality has to provide for in terms of zoning ordinances, correct?
Correct. Mr. Begley, is this a marked exhibit, the appeal of the Redeemed Church?
Yes. It was
Exhibit 03.
03. And I'd like to hand out what you read from, which is 04. And that's 604. So this is the exhibit 04. Simply the language that Mr. Committee just read. And getting back to a question that we both worked on earlier in the cross-examination, multiplex. Mr. Committa, is a multiplex part of the range of multifamily dwellings?
In 04?
In 04, would a multiplex be considered a multifamily dwelling in an arrangement?
I would think so.
Thank you. That's all the questions I have right now.
Redirect.
Mr. Committa, Mr. Bagley referred to the performance standard subdivision, or B14, the performance subdivision, and suggested to you that you could do a garden apartment type use, correct?
Yes.
If it was a single use and you met the criteria, the
Right.
bulk criteria, the individual bulk criteria of the ordinance. But would you not agree that that is the only way you can construct a market rate apartment project as part of a performance subdivision, and if and only if you met all the individual bulk criteria of the zoning ordinance?
Correct.
So it is not a standalone use if you have to meet those guardrails in order to get to that point, correct?
Correct. And also, if one of the uses were multiplex, according to now I'm looking at the definition of B9, you can only have 4 units in a multiplex. So in 50 years, I've never seen anywhere where someone built a 4-unit apartment building. Not in my career. Not in the Delaware Valley, not in southeast Pennsylvania, not in my experience in the mid-Atlantic states.
And in the performance subdivision category, the B14, you would agree that the current jointure ordinance only allows it in one zoning district. So in addition to meeting...
So the answer is yes, I would agree with that.
Right, it's only allowed in the R2 district, and you still have to meet all the individual bulk criteria in order to get there.
Correct.
Okay. With regard to the municipality's obligation to provide, Mr. Bagley's referring to 6044 in the language in there. I think we would all agree that that language is not in and of itself the final word on the subject, and there is multiple appellate decisions in the Commonwealth that construe what that means, correct?
Yeah, early in my career, someone brought in a curative amendment for patio homes and other dwelling unit types that I had never heard of. And so there are many, many, many different arrangements of apartments.
Okay. And no one, I don't think, is suggesting that the B10 use somehow is a substitute for a B11 use as it was originally conceived and as it was subsequently removed from the ordinance.
Correct.
Agreed?
Yes.
Okay. I don't have any other questions for Mr. Committa.
Recross, Mr. Bagley? No?
None.
At this time, it would be appropriate for board questions for Mr. Committa. Mr. Chairman, do you want to lead that discussion in an orderly fashion?
I do my best.
Thank you.
I had a question, and I have lots of notes, and I'm not sure which questions I have, but the one I have circled is, could you go back over what the definitions of de jure and de facto are?
You want me to say more about de facto?
Yes, I'm confused as to what the definitions are.
So, if Newtown Township ordinance were silent to the word apartment, then clearly one might allege that there's a de facto exclusion of the use. It is in fact,
Other way around.
okay,
De jure.
Other way around.
okay.
That's de
So,
jure.
all right, sorry. So the de jure, I believe, and I apologize, I think I said it opposite in my direct testimony, my
You did.
apologies. Yeah, so if it's a de jure exclusion, the exclusion of the use is 100%. In a de facto, when you wind your way through the ordinance and you look at the performance subdivision and the uses and the mix of uses and the very area and bulk regulations, it then it rises to the level of not being practical to do the use as a normative use. So thank you for asking me the question to rehabilitate myself on that answer, because I did have it, I had backwards, sorry.
And I'm not one who has a background. I have a social service type background, so this is kind of, I'm still trying to get all the legal determinations. Let me see if I have one other question. Let me try to give you this one. In your testimony, you said that Newtown Township has the diversity of housing, so why do we need more?
I said actually, the record will speak for itself. I said it has a diversity of uses. And so when I ask myself the question, independent of any of whose opinion is what, is this, so I became aware of the proposed curative amendment. I came to the township and drove around and looked at the different uses and buildings and districts. It was not difficult to conclude that the site in question and the OR district is along the bypass. As I drove through the different roads and streets of the different districts from the southeast corner adjoining Lower Makefield over to Newtown Borough, I saw the variety of office, educational, institutional, and residential uses. So it's just, in my opinion, a logical place to have a B11 apartment use in an area. It's not in the middle of a farm. It's not in the middle of an area that is undeveloped. So, in general, I mean, the site is undeveloped, obviously, that's why KRE is proposing the apartments, but it's not in Upper Makefield, in the northern portion where a substantial amount of the land is the CR district.
Okay. Throw it open to the rest of the group. Mr. Vice Chair, would you like to go next?
I found it interesting that you were talking about the OLI district and the proposal that the Bucks County Planning Commission put forward regarding mixed-use apartment buildings. I think they're maybe 3 or 4 stories high or something like that. And you said, intimated that, well, this indicates that the township is interested in apartment use. Well, we may be in terms of the types of mixed-use apartments that were indicated there. And so I don't think it was, you know, a model for what you want to do, what KRE rather wants to do. It's completely different concept. And as far as the garden apartments are concerned, I'm not quite sure about all the nuances that you were talking about. And when the application was first submitted, there was mention that this was going to be a garden apartment use. And then for some reason, it got changed to a B11 use. Why was that change made in the application? Can you discuss that?
Mr. Mack, I did not know what you just said. I did not know it was originally a B10 garden apartment. But if that's the case, then that, you know, factually, someone will present that. I do
I know
know.
there was a question in there beyond that. The first part of Mr. Mack's comment seemed more of a statement, but if there's a question, Mr. Committa is happy to address it, but if he knows.
Well, can you explain again why you think the OLI-LI is a kind of a model, a kind of sending a message to developers? This is what I inferred from your testimony, that you implied that this was a message to developers that Newtown wants to have apartment buildings of the type that you are, KRE is proposing, and I have a problem, you know, interpreting it that way.
Well,
So is that correct? Is that what you were trying to do with when you brought up OLI-LI?
I think Mr. Mack's asking, what significance do you attach to exhibits A5 and A6 that
sure.
are going to be in front of the supervisors in the near term for
Yeah.
consideration?
Let me first say, Mr.
Correct?
Yeah, let me first say, to answer Mr. Mack's question, Mr. Fisher asked a great question at the end. If I said, you already have apartments, why do you need more? Well, I said in my direct testimony, because you're a growing community and you're proposed to have more people and more housing units. So then the question turns toward, I'm not sure if one morning somebody from the Bucks County Planning Commission just woke up and wrote this, or had some information from the township, some communication or whatever. But regardless, in my experience, I've worked with many planners, and it's not a surprise to me when looking at all the factual information that you would look at the LI and the OLI district for the same reason that KRE looked at the OR district, because it enjoys the access to the bypass, it has the sewer and water, and it's in the developed portion of the township, all ingredients that are appropriate assets for a B11 apartment use, or whatever A5 and A6 are currently drafted to say. So.
Well, I mean, that's what the Bucks County Planning Commission came forward. They were very forceful in foisting, I believe, upon us the mixed use.
I'm not aware of
We
what
never
they
heard
did.
of this before, but the original plan was in that OLI district to increase business opportunities. The apartments were something that the Bucks County Planning Commission is very adamant about. But I was just curious as to your reasoning for using that as an example of the need for apartment buildings. It wasn't something that Newtown went to Bucks County Planning Commission and said, we need more apartment buildings. They came to us and said, you need more apartment buildings of the sort that they recommended, which we have not yet approved, by the way, so.
We are well aware of that. And from my perspective, part of the reason for including those exhibits in tonight's presentation was to ratify, if you will, or confirm what we alleged in the petition, and that was there were several paragraphs that Mr. Bagley sought to have excluded, which ultimately the board elected not to exclude, but referencing the thought among some in the township that your ordinance needed assistance in providing more apartment opportunities than presently existed. The purpose of submitting exhibits A5 and A6 is to indicate, yes, that thought has now coalesced into a document that ultimately the board is going to review. We acknowledge it hasn't been adopted yet, but it will be the subject of discussion and debate going forward. So I think it serves to validate the issue that we raised in our application. So that's the point.
Madam Secretary Treasurer, any questions?
I don't know if you've gotten this far or not, and I don't know if this is appropriate to what we're discussing tonight, but I'm sure you're aware of what's happening in Lower Makefield with the shopping center, as you mentioned, down the road, and the apartments that they're building, and the subsequent congestion that all of that will, I'm sure, add to the bypass. And
I'm not aware of the congestion, so my apologies. I did tour that, and I drove around the in-process construction, but I did not review the development plan, and I haven't reviewed any traffic studies, so I apologize.
so you would say that's not part of what we're discussing tonight, just for my information? And will that be something that you will be looking at? I mean, or is it just you want to build apartments and you're not going to take into consideration all the other issues that we have there? Just for my edification, because
Well, I
first
can
time-
address that. I think your issue is legitimate and needs to be addressed. I don't know that we're going to do it tonight or as part of these proceedings. If we move forward with these proceedings and ultimately someone believes that your ordinance needs to be addressed to provide for this cure we suggest, then we go through the more normal traditional land development process, and issues such as traffic impact and the like, stormwater management, all get addressed in the normal course. So the issue you raised, we all see it. We all see what's happening out there today in terms of the improvements that are not yet finished but are being installed as part of the Lower Makefield job that you've seen. And if we got that far, those issues would be confronted here and we'd have to address them here. But that's where we're at in terms of the issue you raised. That is, in today's proceedings, premature, but ultimately top of mind if we get to the point where we're doing a land development plan.
Mr. Calabo, while I'm looking that way, you have a question?
Absolutely. I'm just going to just clarify with one of the last things you mentioned. Did I hear incorrectly that you never heard of anything as a 4-unit apartment building?
Well, I've never designed one. I've never reviewed a plan for one.
But you never heard of a 4-unit apartment. A dwelling that has 4 units is not considered an apartment building?
Well, when it's a block, I have not seen a block that, in my experience, in any place I ever lived and reviewed plans, that had a 4-unit apartment building. I just haven't seen it.
Okay, so you're not familiar, in your 50 years of experience, you're not familiar with a 4-unit apartment building?
When I
If you
grew
wanted
up,
to go borrow money at a bank, it wouldn't be a residential loan, you'd be borrowing on a 4-unit apartment building, not a residential building. I just want to clarify this because I can't believe you never heard of this. That's just my opinion.
No, I
I'll
haven't.
I'll move on from there. I'm sorry. Are you familiar with the reason of the jointure?
I'm sorry, am I familiar with what?
The reason of the jointure?
What is the reason, plain reason for the jointure?
In general,
Because I hear you mentioning about Upper Makefield has a lot of CM district, and so
Sure.
does. Do you know the reason why Newtown is Newtown? Is because we agreed to absorb the density and the business and things like that? Are you aware of that?
I'm generally familiar with
Okay, so
the
you're-
municipality's planning code and jointure opportunities.
Okay, because you spouted off about how all the other townships had all this massive space, and we didn't, but there's a reason for that.
Okay,
And the reason that we agreed to it is because we are fulfilling their basic obligations for whatever zoning they're not using. for
That's
the
great.
jointure, okay?
Yeah.
Now, how many jointures have you run into in the state of Pennsylvania? Trick question.
I have run into them mostly in other states.
I didn't ask you about other states.
Well, not in Pennsylvania. This is the only one in
This is the only
Pennsylvania.
one, and you're not even familiar with it, we're the only one.
Well, I mean, I've been around the block. I've heard about it for many years. It's just that I haven't had the good fortune to work here before.
Okay. Now, you had mentioned about apartments and something about 20 units per acre, but I didn't see any reference to how many acres that would be on.
Yeah,
Would
so
it be 5 acres?
I
You
was
think
looking,
that's it?
yeah, it's a good question. So in Exhibit A5, on the bottom of page 3, I made reference to the 20 units per acre. Let me take a quick look and see if they also recite a minimum parcel size. I don't see it. Maybe it's in A6. Let me take a quick look. Yeah, the only number that shows up in this draft is on the top of page 3 of Exhibit A5, where they say the minimum lot area is 80,000 square feet, which would be a little less than 2 acres. 2 acres is 86,000 and change.
So 20 units on 2 acres, per acre on 2 acres. So that's only 40 units. And I'm not very good at math, but is that correct, do you think?
Yeah, so you'd have to have a minimum lot area of 80,000 to do it according to this draft.
Let's say hypothetically it's 5 acres.
Sure.
So now you're talking about 100 units on a 5-acre property.
Correct.
How many units are we talking about in this particular development?
I have to check. I have the curative amendment, but I don't have the site plan.
I mean, either Mr. Murphy or you have the developers right behind you that can
250.
answer this question.
About 250 units.
250 units. And that's on 15 acres, is that what that's?
18.
18 acres. Okay, so 20 units on 5 acres is 100, 245 on 15 acres, I don't know, it seems kind of excessive. Now, not to get into, in your experience of planning, have you ever done any kind of traffic studies?
I have not. I'm not a transportation engineer.
Okay. But you said you've driven those roads, you've driven Silver Lake and so on, you see it's a
Yeah.
two-lane road. I mean, in your professional opinion, 245 homes, I'll even calculate it, 2 cars per unit. You think that 2-lane roadway could handle another 500 vehicles on that roadway?
You'd have to look at a traffic study, and I haven't seen one, so I'd have to double check that.
Okay. Well, I'm not a
That's-
traffic,
It's like Ellen's question. We're going to have to get to that point at some point.
Well, but you have to have an idea before you even get to that question.
Phil, we already have a 200,000 square foot office building approved with over 1,000 parking spaces for that site. That could easily be
Well,
accommodated.
that's almost kind of
And
impossible,
we're
too.
talking about a density, Phil, when you go through those numbers, our density is
I
proposed
believe,
is less than
am I
14.
cross-examining you or him?
Well, I'm trying to help answer the
Well,
question he doesn't know.
he should be the
He's
experienced
not a
person in
traffic,
this.
he's not a
I
traffic.
asked him for his professional opinion
But he's not a
of,
traffic
he
engineer.
blurted out 50 years this, 45 years this, I did this, 113 different municipalities, blah, blah, blah.
As a
And he
planner.
can't give me his opinion.
As a planner.
Okay, very good. Now, let's go back to the study that was done July 2016,
You're talking about the DVRPC?
DVRPC, yes.
Okay.
Okay. Have you taken into consideration any developments that may have done after this study was done?
Mr. Bagley asked me about that. At the time earlier this year that I
Now,
checked,
he asked you if you had any updated information. I'm asking if you're aware of any new developments that were done after 2016.
in Newtown Township?
Well, yeah,
Yeah, I haven't looked at that, no.
okay. Now, I know it's a minor issue, but looking on the 2045 Figure 1, I think you mistakenly classified Newtown Township. I thought you had mentioned it was 6,000 to 12,000, but it's actually 12,000 to 24,000 in the shaded area.
Yeah, you're correct. It is the more orange color.
Okay. And I'm assuming, I'll just give a guesstimate. It says here 2020, the population of Newtown Township was 20,059. And can you explain to everyone what the term forecast means?
Sure. So when I started my career, the same publication by DVRPC would have been called Population Projections. And I would say in the last 20 years, Pennsylvania State Data Center, Delaware Valley Regional Planning Commission, Bucks County Planning Commission, all the county planning commissions now reference forecasts because in the methodology that they use to project the future, they are at the mercy of whatever that data is. So instead of calling them projections per se, they call them forecasts because I think they view it as a slightly softer way to think about the future. So for example, if you were to disagree with them and you called DVRPC and asked them how they do it, and they shared the intricacies of their model, they would also share that they looked at sewer service areas, they looked at developed land and undeveloped land, and they put it onto a model, all of which comes out with the word forecast instead of projection.
Okay. Forecast or projection, it could be also a guesstimate.
Like when you turn on the weather tonight, it'll say the weather forecast for tomorrow is,
50/50.
and then you think it's going to rain, but then it doesn't rain for 3 hours later because the wind changes. They don't say the weather projection is. So everybody likes to use the word forecast.
Yeah, I'm glad you mentioned the weather because it's a great thing to be wrong every day and still have your job. So, I mean, are you telling me that these forecasts can be wrong and you can still have your job as making these forecasts?
Yeah, the fun part of working 50 years is that I've gone back to the old forecast and checked them after the next census, and they're within like 5%.
Okay. But, again, we're 20,000 now. This forecast, 2045, is an increase of 21,500. And this is under the consideration that it's going to increase, never decrease,
Correct.
okay? So, like you said, a forecast is like the weather report. Partly cloudy means also partly sunny. So this forecast, in my opinion, means nothing. So to say that we need these particular apartments to fulfill our forecast is, you know, pretty much smoke and mirrors.
Well, I don't think that it is smoke and mirrors, because go back to 1990, go back to 2000, go back to 2010, you haven't shrunk in size. You haven't.
You're looking at a different time period. You're looking at a time period where Newtown Township was in a growth stretch. We were developing. We were having more developments being done at that time. Right now, we're at a situation where we are almost built out. So to use that time period from now to 2045 is a very unfair thing to do.
Well, you could go back 5 years. Sorry that I went back to 1990. Think about 5 years ago. Is there anything different today than there was 5 years ago? Are there more people?
Yeah, there's things different today. We have 2 developments going on right now.
Very good.
But most of our new development may be tear downs and rebuilds. We're not talking about a 245 unit property. Now, you've driven this property, you saw the land, you saw where it's going to be located. Are there high tension wires that go through that property?
Next one down.
Close enough?
Yeah, just,
Jason, below.
yeah, on
Okay.
unit 2.
So this would be a proper place, in your opinion, for residents to live within the area of high tension wires?
Well, the proposed building is north of that, so it wouldn't be, they're not living underneath it.
Well, not living underneath it, but
Yeah.
in a close proximity to it.
Yeah.
The other thing you had mentioned is why we need these apartments in Newtown, and you kind of explained that. But then you said something that I just wrote down, affordability. What is affordability?
Yeah, so my 98-year-old mother,
Can live in these apartments?
possibly. So
Okay,
my
she's very well off.
98-year-old
I
mother.
have to commend your mother, she's very well off.
All right, let me finish. My 98-year-old mother no longer works. She's on a fixed income. She lives in a continuing care retirement community in the smallest of the units. My son lives in an apartment in Brooklyn that's 5 times the size of my mother's apartment in Westchester. So it really just depends on, you know, the diversity of the makeup of the community. So, yeah. I mean, think about all the places where we've all lived. Most of the time, we've lived over the years from something smaller to something larger, except when the empty nesters go back to the apartments and downsize.
Okay, that didn't explain affordability, but I'll give you some leeway on that, though. What are the heights of these apartment buildings?
Bill, we're not at a point where we're talking about the design of.
Well, I want to get the idea, what the height of these apartments, we could assume what a height of the garden apartments would be, because usually they're only 2 stories. How many stories would these entail?
Not to exceed 6 stories, so the mid-rise
6
apartment use
stories,
is in the 3 to 6 range.
6 stories, okay. So 6 stories at, say, ceiling height 10 feet apiece, you're talking about probably, with a little bit extra space, of 75 feet in height.
I don't know the exact number, so I apologize, I don't have that number.
Okay. Be the highest buildings in Newtown.
I don't know that.
Well, it would be, I'm letting you know, yes, it
Okay.
would be.
Bill, there are we understand that there are height limitations in the ordinance. We're not here to debate that. We're talking about what we
Well, I
allege
think
to be a
it's
defect
good
in
to
the
know
ordinance.
these
If you're
things.
if
It's
you're
good to
willing
know these
acknowledge you have a
things.
defect in your ordinance, we'll sit down and talk about all the others.
But I think it's good to know these things ahead of time, to know that we're going to have buildings that are going to be the highest buildings in
Did
Newtown.
that
I know that
a year ago, we presented.
245 units at 2 cars apiece, 500 cars are not going to be ample for those roadways.
Phil, we're not here tonight to talk about, we're here to talk about what we think is a defect in the ordinance, not individual design elements of the plan.
Can you, just for my knowledge and maybe some other people's, we always throw the word out there, curative amendment and all that. Can you explain to me what a curative amendment is?
Sure. So when I started my career in 1973, the municipality's planning code has a section in it that describes a landowner's administrative remedy to approach a governing body like we're doing to identify what we believe is a defect in the ordinance and then to articulate why we believe that. And there is a procedure, and Mr. Sander is following that procedure with the hearings and the way Mr. Sander outlined the protocols, and here we are. So it's not unprecedented. Many curative amendments have been submitted in Pennsylvania, probably over 3,000.
And you've done, I know you mentioned, but you've done how many curative amendments?
So I've been involved in about 30 curative amendment cases.
And none of them within a jointure because there are no other jointures.
Correct.
Okay. All right, that's all. Do we have a chance to question this gentleman as we go on, or?
No, this is your chance to question Mr. Committee.
Okay, thank you.
Thank you for your questions. Thanks.
I have one more thing to share with you. I'm sure you're aware that we're working on a new comprehensive plan right now. Since you see it's 14 years old.
I've been told about it.
you
I
must-
haven't followed it.
Right. The projections of growth that you're talking about isn't substantiated in the new projections for the comprehensive plan. So,
Very good. Yeah, I haven't seen it.
I mean, there's a big difference, a
Okay.
huge difference.
Yes, so I was going to mention that. I'm looking at it right now. Table 1 of the plan says the growth from 2020 to 2030 will be 224 people.
Okay.
That's what the Bucks County Planning Commission has gotten from the U.S. Census Bureau. And there was a recent article, I think, I don't know if it was the Times or the Patch, where the population of Pennsylvania has decreased recently. Now, I don't know about Bucks County, but and the Bucks County Planning Commission said we had adequate space using the current housing to accommodate these 224 new people that will be here by 2030. I don't know about 2045, but, you know, in 10 years, you get an increase of 224 people. That's 22 people a year, so another, I don't know, 300 people by 2045.
Yeah, I haven't seen and reviewed what they did, so
Well, I think you should take a look at that because you have cited the Bucks County Planning Commission thinking that telling Newtown you need apartment buildings, but Bucks County Planning Commission.
That's not why we did it, John. We cited exhibits A5 and A6, which were, we understood.
You talked about your OLI and LI.
Hold on, gentlemen, you can't, both people can't speak at once because our court reporter cannot take down both people. So we've got to let one person speak and let's speak individually. Thank you.
As I recall, you mentioned the OLI-LI district as evidence proving that an independent organization, the Bucks County Planning Commission, thinks Newtown needs apartment buildings because you intimated there's an increase in population of so many thousand, whereas the Bucks County Planning Commission does not see that kind of growth and the need for Newtown to have high-density apartment buildings for 224 people.
Yeah, I haven't seen it. I haven't
Well,
looked at
I
it.
think you should take a look at it, maybe.
We submitted exhibits A5 and A6 to suggest that others besides us believe that there could be an issue with your ordinance. We think there is a defect in your ordinance because you don't have a standalone use for market rate apartments. At least one other planning agency believes that Newtown Township needs to do more to provide a wider range of residential opportunities for its citizens, both present and future. That's why we did it. It doesn't change the fact that we think your ordinance has a defect that doesn't allow us to proceed. That's why. And it happens to be where your consultant thinks might be a logical place for it to be located. We're right across the street from it. So that's why we think it's wrong. That's it. And we know it's not adopted, John. It is a topic for conversation and which is going to continue. It doesn't mask the fact that we think the underlying issue here is the ordinance itself.
You mentioned that the B11 use was taken out of the ordinance in 2005, is that correct?
Right.
And from my conversations with the Joint Zoning Council, which is responsible for writing the ordinances, they claimed it wasn't necessary. There must be a reason why they thought it wasn't necessary. I'd have to go back and see if I can dig up the minutes of those meetings to really find out what they were thinking. And have you ever done that? Have you looked at why?
It's in our application. That
It is?
Yeah, the ordinance itself, repealing it, is in our application and it says why.
Well, yes, I know, but you don't know why the
I know
joint-
what the ordinance says, and it says that
Do
the
you know
township
what-
thought it
I'm
had
asking-
already
Okay, hold
provided
it,
a wide
gentlemen.
array of uses.
I'm asking, do you know why the Joint Zoning Council decided that it wasn't necessary?
I know only what the ordinance on its face says, and it says the jointure felt it had already provided a sufficient array of residential use.
Okay, but you're citing experts like the Bucks County Planning Commission
I'm
says
looking
we
at the
need this.
ordinance.
Wait, the Bucks County Planning Commission says we need this, we need that, but I'm telling you, the Joint Zoning Council said we don't need this. And now you don't know why they said that. I don't know why they said that. I'd like to go back and review that to see if this is really necessary, because that's what you're arguing about. It's necessary for us to have this. This is your opinion. It's necessary for us to have this in our ordinances, whereas the Joint Zoning Council has said it is not necessary. Now, there's two different opinions here.
Right?
That's why there's
Right.
two different tables up here. And you'll hear their legal arguments when we get to that point.
Right.
Mr. Davis, before we get to you, I just wanted to, my population projections that I saw, actual population for 2022, 23, we were just under 20,000. I think it was 19,895 or 985. But it was very close. It was like a couple of handfuls of folks, just under 20,000. And then I just had one real quick question. When the question was asked about this is Exhibit A4, I missed what the projection was. It was the blue color, Figure 2. No, I'm sorry, it was Figure 3. Or was it Figure 4? Hang on a second. Yeah, it was Figure.
Where are you, Dennis?
Figure 3. What range were we?
Figure 3?
Yes. Figure 3. It's the blue, light blue.
It appears that it's under the moderate growth.
Okay. I thought so too, but I just wanted to check because I missed it.
Okay.
That's all I have, Mr. Davis.
Thank you. having the privilege of going last, some of my questions were already asked. So all I have, Mr. Comita, you said you drove around the township looking at different uses and whatnot in our zoning. We have some buildings that I would qualify as apartments that seem very similar to what you're saying that we may need. How would you classify Liberty Square, or I don't know if you're familiar with it in your travels, Liberty Square apartments over at Newtown Crossing? How would that be different from what we're looking at here? I'm trying to...
I didn't see them. Can you tell me where they are again?
Yeah, they're in Newtown Crossing off of Mill Pond, thank you.
I would have to look at it. I'm sorry, I did not.
Okay. And then I would same question for Crown Point. I don't know if you got over there in your travels either.
Yeah, I didn't see those.
Okay. All right, then that's all I have. What's that? Yeah, those are two I was thinking of. Thank you. Thanks. That's all I have.
Any other questions? Toss it back to our solicitor.
Okay. Looks like we've reached a stopping point for this evening. The next board work session is October 16th, but I am not available that evening, and we're going to have to come up with another date for the next hearing. I would like to recommend that rather than sit here in the room tonight and have everybody check their calendars and start picking dates and throwing them out and picking other dates and throwing them out, that the board consider a motion to continue this matter to its regular meeting of October 11th, but only as a placeholder. We don't expect to hold a hearing that night, but what it will do is give us time to poll everybody and find out when, A, this room is available, and B, all of the supervisors and parties are available at some point in October, after October 11th, so that we can then continue the hearing on October 11th to that date certain that we have chosen in the interim. So is that agreeable to the parties?
Yes, and October 11 is a very viable date as well.
Is, okay. I know the Board of Supervisors has a regular meeting agenda that night, and I don't think that we're going to be able to fit in another hearing, but I understand what you're saying, Mr. Bagley.
Okay.
Mr. Murphy, is that a...
Same.
Thank you, thank you.
So my understanding, that's as a placeholder date.
It's a placeholder date. We're going to continue it till then, and then on October 11th, we will make another motion to continue the hearing to a date certain. So at this point, is there a motion to continue this hearing to Wednesday, October 11th, 2023 at 7:00 p.m. at the Newtown Township Building?
Need a motion? Go ahead.
Is there a second?
Second.
All in favor signify by saying aye.
Aye.
We are continued to October 11th.
And that adjourns us for this evening.
And that adjourns us for this evening.